Everyone. My name is David Gallo. I'm the director of the AIFC Academy of Law, and we welcome all of you who have joined us from Europe, the Middle East, and Central Asia, and anywhere else in the world that you may happen to be. Welcome to all of you. We appreciate the opportunity to take about the next hour to talk with you today about a very important subject when it comes to commercial law, commercial transactions, and things that sometimes can go wrong, and the best way to respond to such events. So today's topic is on the subject, how to use insolvency to assist international asset recovery. And we are truly privileged and honored to have today's speaker with us, Mr. Jonathan Thielmann. Jonathan's the Director of Insolvency and Asset Recovery at Grant Thornton UK LLP. Jonathan assists clients with the recovery of assets which have been misappropriated as a result of fraud. He uses the UK insolvency legislation to complete investigations globally, and he works closely with lawyers to formulate legal claims within bankruptcy or liquidation proceedings to increase the funds available to repay the creditors who have suffered loss. Jonathan is qualified as a chartered accountant in Australia, and he has worked with businesses suffering economic pressures to restructure their operations and to devise workout arrangements as an alternative to or within non-contentious liquidations and bankruptcies. He has extensive experience with investigations connected with Russia, Ukraine, and other countries in the Commonwealth of Independent States. This commonly involves enforcing foreign court judgments and arbitration awards in the UK, or tracing assets and commencing insolvency proceedings to assist recovery strategies in commercial disputes. So keep in mind, this is a fairly specialized area, and Jonathan Thielmann is one of the leading experts globally in this area. So please take note of his details. And if Jonathan can ever assist you with any of your issues that you may be having with your corporate clients or otherwise, please keep Jonathan in mind. And before the session started, I was just talking to Jonathan about how we welcome him back at any time to join us in these learning and development platforms. So stay tuned, more to come. With that, it's my privilege to turn the floor to Jonathan Thielmann. Jonathan, nice to see you.
Thank you very much, David. Such a kind introduction. And welcome to everyone who's joined us today, or is indeed rewatching as this runs on YouTube. Pleasure to have you. As David's explained, today is really intended to be a how-to guide to explore the ways in which we have used insolvency as a tool to trace and recover assets for creditors, clients who have suffered loss, and that may be as a result of fraud or the business relationship having deteriorated to the point where the creditor cannot procure payment. Having looked back through some of these very informative webinars that David and his team have comprehensively run during this unusual period we're all living in, I noticed that there have been a couple of sessions already presented around the topic of insolvency. And having reviewed those, I think it's probably quite helpful that this is the third part to follow to give that how-to explanation. Professor Mark Moore in June presented on the fundamental principles of insolvency, talking through an insolvency event and creditor categories, etc. Then very helpfully thereafter, Tetiana Nesachuk from Fountain Court Chambers here in London presented on the AIFC insolvency regulations and spoke through about what insolvency procedures were available and the law and regulatory process which needs to be followed to deal with an insolvency event within the AIFC. Now, today I'll walk through a case study in detail, which is a live case that we're currently working on, but I think it's fair to say has reached its near conclusion. And the intention is to explain how some of those powers, the regulations which are afforded under the AIFC insolvency regs, and what we similarly have here in the UK, can be used by insolvency practitioners for the benefit of creditors, clients, to achieve recovery where that may not otherwise be available. So a brief agenda for today's webinar. I'll give a short introduction about Grant Thornton, the type of work we do, and in particular, the work that we've done in Kazakhstan and the CIS region. I'll talk through then in some detail about the particular case study. Thirdly, I'll move on and talk about some key lessons which you all may be interested in to take away from this case study and how that may apply to your clients. And lastly, just to wrap up and highlight some of the areas of similarity and overlap between the AIFC insolvency regulations and what similar tools we use for insolvency processes here in the UK. So a bit about Grant Thornton. We are the largest dedicated team in the UK of accounting professionals that provide support to lawyers in the context of disputes. I would say that we have about over 250 people. That spans our forensic investigations, valuations, cyber security, and insolvency and asset recovery practices. So that's not the entirety of the firm, but is these particular areas which are often required to support lawyers in the context of disputes. Being one of the largest teams in the UK, by consequence, we believe makes us one of the largest teams in the world. That is enhanced by our presence in having member firms in each of the Commonwealth of Independent States, and we regularly work alongside our colleagues in Kazakhstan. Similarly, we have offices in many of the most prominent offshore financial centres. That is particularly relevant for CIS-related disputes because in our experience, the transactions usually involve companies that have been registered in, for example, Cyprus or the British Virgin Islands or the Cayman Islands. And our presence, having offices and experienced professionals in those jurisdictions, sets us apart from some of our peers in being able to comprehensively pursue international asset recovery opportunities. So a little bit of background about what we're talking today and why this may be relevant for you and your clients. And I approach this from having had a consideration about the particular categories of clients that we usually work with. Starting from the top through the list, banks and financial institutions. We have experienced projects where lenders may have a portfolio of non-performing loans and they need to take steps to enforce their security through insolvency proceedings to try and recover the value for that. Similarly, like today's case study example, banks may have taken personal guarantees from the shareholders, directors who own the businesses. And although the company itself may have gone into liquidation or some other insolvency process, there is often the ability for banks or financial institutions to further pursue the recovery of debt by enforcing these personal guarantees. And I'll talk about that when we get to the example a little bit later. With regards lawyers, they are very regularly working with clients to obtain legal judgments or arbitration awards for their clients in order to achieve some financial recovery. Obtaining that award or judgment is not necessarily the end of the road. And it's at that point that we often become involved by identifying the location of the opponent and then assisting the lawyers enforcing that judgment, which may result in a bankruptcy process for that opponent where we need to trace and recover the assets to meet that legal judgment or the arbitration award. Finally, as you may expect, is corporate stakeholders generally. In any business transaction or operations, there are a myriad of corporate stakeholders involved, such as suppliers or other joint shareholders in SPV arrangements who may have lost out as a result of a business transaction. Examples of issues there may be outstanding debts, your supply arrangements for which haven't been paid, and the powers of insolvency can be used to apply some pressure to companies or individuals to procure payment under those arrangements. Similarly, any breaches of contract can be pursued through an insolvency process for financial recovery. That comes on to why we here in the UK are talking about this and the relevance of an English insolvency practitioner speaking about international insolvency for clients in Kazakhstan and the Commonwealth of Independent States. We regularly see the UK arising in CIS and former Soviet Union disputes, including out of Kazakhstan, because the UK and particularly London remains a desirable location for high net worth individuals to relocate to. It is no surprise that Kazakhstan still remains one of the most prominent litigants here in the English High Court. Naturally, as part of today's webinar, we anticipate to see that some of those disputes will transition back to the AIFC court as that continues to establish, and we look forward to seeing that grow. By consequence, having a comprehensive insolvency regulation as the AIFC has established will be required to provide clients, creditors, stakeholders with the necessary powers to comprehensively pursue an asset recovery process. Otherwise, here in the UK, many lifestyle factors exist which bring individuals here and which generate our involvement. And that can often be because individuals have family connections here, children may be at university or other education, and simply establishing a second residence here in London as a safe haven for assets. Naturally, with Brexit on the horizon, we will yet see whether that continues, but for the time being, the tool of an English insolvency process is still very powerful in enforcing debts and judgments. So, onto the case study, and just to tell you a little bit about the background first before we drill into some detail. So, this is a project that we have been working on since 2017 and remains a current live project. And for those reasons, I can explain in some detail the types of assets we've recovered and what we have considered, but for obvious reasons, names, etc., have been redacted. This commenced in 2017, but I don't doubt that the issue existed before that, as that was the point at which we became involved. So in the background, a Russian company went into bankruptcy proceedings in Russia. The CEO of that company had provided personal guarantees over his assets for the bank lending to the company. The Russian bank was therefore owed £200 million approximately from the bankrupt company as a result of the liquidation. That debt was in part secured by personal guarantees provided by the CEO. The CEO then attempted to avoid his obligations under those personal guarantees and had relocated to London in the UK. The Russian bank was then required to seek recognition of that debt in the UK to pursue the CEO individual who had relocated there. It was at that point that we became involved, and Grant Thornton were appointed bankruptcy trustees over that individual to assist the Russian bank, but also all of the creditors in the bankruptcy with pursuing assets from the bankrupt. As you'll see over the forthcoming slides, we coordinated a team to recover assets which were located throughout the world, ultimately for the benefit of the Russian bank and other creditors, where they may not have otherwise received any recovery under the personal guarantees. So just rewinding back to the previous slide, this is a neat example of where insolvency as a tool has been used to pursue and enforce personal guarantees. So just looking back through those facts, we can analyze those briefly in terms of some issues that were faced and what actions were taken and solutions achieved to realize some value. The first step was there was a shortfall to creditors, such as the Russian bank, in the liquidation of the Russian company. Therefore, in addition to the Russian liquidation process taking place, there was the opportunity for the Russian bank to enforce its security over the personal guarantees provided by the CEO. However, the CEO had relocated to the UK. The creditor was therefore required to have their judgment, their personal guarantees, recognised in the UK. Despite that, there was no cooperation from the CEO. Consequently, the creditor was able to petition for bankruptcy. That meant that Grant Thornton were appointed as trustees in bankruptcy over the individual's assets. However, the bankrupt's assets were located throughout Europe and the rest of the world, and therefore it wasn't a simple process of realising those assets in the UK, but we, Grant Thornton, were required to go and trace and identify assets and realise those wherever they may have existed throughout the world. Therefore, in summary, we went from a position where the CEO was avoiding their obligations under a personal guarantee to using the insolvency process to successfully execute an international asset recovery strategy and recover monies for the creditors. So, before we get into some detail on the particular case study, it's worthwhile just looking at how insolvency can be used to assist investigations to actually achieve recovery. You'll be very pleased to know that the AIFC insolvency regulations are very similar to those insolvency laws and powers we have here in the UK. The relevance of that is many of these examples, which I will talk through now as tools that we use here in the UK, are also available to insolvency practitioners in the AIFC court. Therefore, many of the ideas and suggestions that we make as part of this webinar are available in the context of Kazakh disputes. So just to rattle through some of the powers and tools that we use to execute our investigations. An insolvency practitioner, and that may be a liquidator of a company or a trustee of a bankrupt individual, is able to summon any person to provide information about the company in liquidation or the bankrupt, providing that person can reasonably be expected to have information. So that then opens up the opportunity for an investigation into many associates of the company or the individual. That may include the banks with whom the company banks with, lawyers for the individual or the company who may have documents about asset sales, asset purchases, or other transactions. And of course, accountants, auditors, and other financial representatives of the company. They are obliged to provide information to the insolvency manager, but if that information is not forthcoming through cooperation, the insolvency manager, such as the liquidator, has the power to ask the court to make an order directing that cooperation. In addition, a liquidator has the power to interview directors of companies or bankrupt individuals, or indeed secretaries, employees, or any member who indeed can be assumed to have information about the company, which can be a powerful tool to gather information as part of the investigations. The insolvency practitioner can collect all the books and records of the company. That's not limited to what the company itself has in its offices, but that may include such things as bank statements from banks and also client ledgers from law firms, which have processed asset purchases or sales on behalf of companies or individuals. Such avenues may be rich sources of information in the context of an investigation insolvency. All of these legal powers that an insolvency practitioner has available to them are supplemented by corporate intelligence, which is undertaken to identify assets as part of the investigation. For example, we regularly use social media, investigate public databases such as land registry and corporate databases, and mass media searches to try and formulate a picture about where the assets may be available to recover. Ultimately, the intention of all of this is that it leads to the identification of assets which can be recovered for the benefit of creditors. So, stepping on to our particular case study here, like I explained, we were appointed bankruptcy manager in 2017, which meant we had the responsibility for realizing the individual's assets worldwide for the benefit of his creditors. This is an example of the types of assets that were revealed as part of our investigation process, which I explained in the previous slide. Having traced through bank statements, reviewed legal files, and client accounts held at law firms, we were able to determine the individual's financial interest in these assets. As you can see, they included all of the types of assets that one may expect of a high net worth individual who is a CEO of a large company. Yacht berths in Italy, including an associated yacht moored, a villa, residential premises in Italy worth in excess of 10 million euros, a vineyard estate, residential properties, including vacant land in Germany, cash in investment accounts that spread across various jurisdictions, including Cyprus and the UK, and a residential property in the form of an apartment in Dubai. That is a selection of some noteworthy assets which we identified as part of our investigations process. As you can see, the combined value of these assets is well over £20 million, which is significant as an additional recovery for creditors, and in this instance, particularly the Russian bank, to enhance their recovery in addition to what they may receive out of the Russian liquidation. Of course, £20 million does not quite match the £200 million which they were owed under their personal guarantee. However, it must be remembered that £200 million was not the amount which the bank had lent to the particular individual. That was simply the shortfall in the liquidation. And this process was an additional opportunity to recover assets for that shortfall. This slide particularly highlights the location of assets being throughout Europe and indeed the Middle East, and that under the UK insolvency process, that is not prohibitive to us achieving a recovery. Indeed, we're obliged to realise assets worldwide, and therefore we will take our insolvency process, our appointment, and use that to recover assets, whether that may be throughout Europe, such as Italy, or indeed Cyprus and Dubai. This next slide provides a brief structure chart about the relationship of various parties in this insolvency process. As I've discussed previously, there was the Russian bank, who was the lender to a Russian company, identified at the top of this tree diagram. As a result of that insolvency, the Russian bank was able to enforce their personal guarantee over the owner CEO of that company. That individual had relocated to the UK, therefore a UK bankruptcy process resulted. As you can see here, there are not many assets held in the individual's own name. You won't be surprised that that is not uncommon in such business structures. That said, my key takeaway point from this slide would be, do not be deterred or intimidated by the existence of a complex offshore ownership structure. Companies registered in the BVI, Cyprus, and other offshore locations often have a connotation of difficulty and additional challenge. I do not underestimate the steps that are involved, but occasionally there can be some easy mechanisms through which to realize assets. As you can see on this slide, some of the assets which we discussed on the previous slide were held through ownership structures. For example, properties in Germany were held by a German company whose shares were owned by a company registered in Cyprus. It was the shares in those Cyprus company which were ultimately owned by the bankrupt individual. As part of the insolvency process, we therefore had an asset being the shareholding in that Cyprus company. We were able to use our powers holding those shares to arrange the replacement of directors of that Cyprus company. And through taking control of these structures in that fashion, we were able to efficiently take control of the particular assets and execute a realization process to realize value through the structures. It must be noted, though, that such corporate structures cannot simply be ignored. The legal framework, the legal structure of the companies must still be respected, but we can use that to realize assets. And therefore, upon the sale of the underlying asset, mechanisms can be achieved to distribute the funds through the structure, such as dividends on shareholdings or indeed the sale of shares to realize value back into the bankruptcy estate. Now, just to talk through some additional powers, if you like, that an insolvency practitioner has, and that is regularly used to try and increase the assets which are available for realization for the creditors. Once again, you'll be pleased to know that many of these tools that we use here in the UK are replicated within the AIFC insolvency regulations. Just to talk through a few of these examples, there is the ability to challenge any transfer of assets for which there appears to be no commercial benefit. Examples of that might be the transfers of shares or property for no or very little value. That may be the transfer of a house or real property assets or a business premises to perhaps a related company for no value or no consideration. Other examples might be the unexplained transfer of significant amounts of cash that may be identified from the bank statements. As you can see here, particular regulation references to the AIFC insolvency regulations have been identified. I haven't also identified the similar provisions we have in the UK, but having reviewed the AIFC insolvency regulations, and as Tatiana would have explained in June, they're very similar between the two jurisdictions. Secondly, where there are circumstances where a company may have inappropriately paid a creditor in priority to other creditors. Professor Moore explained the pari passu principle, whereby all creditors should be treated equally. If prior to the insolvency event, the company or bankrupt individual has paid one of their creditors, perhaps a related party, in advance to any other creditors, such transactions can be challenged to restore the position to a point of fairness, which is the underlying principle of the insolvency regulations. That may include such things as payment of intercompany loans, where such transactions may have been executed prior to the insolvency event to transfer monies to companies related within the group structure. These types of transactions may be reviewed and challenged. Lastly, there is the ability to challenge situations where security has been provided to existing creditors over assets in the short term leading up to the insolvency event. Similar to the point we explained previously, but rather than actually paying the creditor's debt, the company may have given up a secured amount, a secured entitlement to some of its own assets to that creditor to provide them with a guarantee of payment. Those transactions may also be challenged. An example of that may be if a related party, by way of an unsecured loan, was provided with security over a particular real estate asset, and such transactions may be subject to challenges like these. I think a key point to take away from this is that these are tools which are complementary to the insolvency practitioner realizing the asset of the company or the individual. And what you may experience is that this runs simultaneous to the asset realization process. So in the example we discussed earlier, whilst we as bankruptcy trustees are realizing assets located throughout Europe, there can also be an investigation ongoing to ascertain whether any such transactions like this have taken place and whether there is grounds for bringing further claims to swell the assets for the benefit of creditors. As you can imagine, these are all legal processes and often take several years to develop and actually litigate. Therefore, these processes may start early, but value may not be procured for these until later on during the life cycle of the insolvency. So to wrap up on some key points to take away from the particular case example that we've spoken through, the English insolvency powers, which are replicated in the AIFC insolvency regulations, are wide-ranging, and they ought not be underestimated as a tool for clients to be able to pursue asset recovery through an insolvency process. We discussed the power to undertake investigations by collecting books and records from any party who may have information about an insolvent individual or company. We also looked at the ability of an insolvency practitioner to analyse the flow of monies, tracing through and identifying assets, who the owner of those assets are and where those assets are located. And finally, we discussed the the types of transactions which may be challenged by an insolvency practitioner to further increase the amount available to unsecured creditors. Otherwise, I would highlight that there is power to trace and recover assets worldwide wherever they may exist. In the particular example that we've discussed today, we considered assets located throughout Europe and the Middle East. In the types of cases that we deal with, that is not uncommon. In this instance, in this example, 12 countries arose in various aspects in this project. So don't be underestimated or defeated by the prospect of pursuing assets which are located in foreign countries. Related to that is the existence of complex offshore corporate structures. It can be intimidating, but I would encourage clients to speak with professionals, legal professionals and insolvency professionals who have experienced challenges before and have ideas about mechanisms through which value can be extracted from such structures. And insolvency is but one of the tools available for this process. Finally, just to talk a bit about time frame, as I explained, this process, this project commenced for us in 2017, and although we are at the final stages, it is still ongoing. I would say that a 3 to 5 year window is a very common and fair calculation of how long the asset recovery process takes, and clients ought to have that in mind when anticipating the timing of recovery. Separate to those is just to consider cost and funding solutions. As you will be familiar from the AIFC insolvency regulations, the costs of an insolvency process are met by the assets within that liquidation or the bankruptcy of the individual. Various issues may exist where there are no apparent assets at the outset from which to pay the insolvency manager, their lawyers, and all the costs involved in executing the investigation. I would highlight that if there are no assets immediately available for realization, that is not necessarily preventative of such a process taking place. Many insolvency practitioners, such as ourselves, will offer flexible fee arrangements, which enable the project to be commenced, but for the risk to be compensated for later in the assignment once the assets have been realized. Alternatively, funding solutions may exist. You may be familiar with third-party litigation funding, and the insolvency practitioner can utilize such mechanisms to achieve recovery for the benefit of creditors, providing greater access to justice. So this is just to highlight that if you or your clients are faced with circumstances where there are no assets apparently available, but the suspicion is that value has been taken, there is the opportunity to pursue those, not necessarily at significant upfront cost, and speak to me or other legal professional colleagues or insolvency practitioners to consider what's available. Finally, just to tie together with the presentations, the webinars that we've previously had from Professor Moore and Ms. Nesterchuk, they explained the insolvency processes under the AIFC insolvency regulations. Those included the company voluntary arrangement, receiverships, and particularly liquidations, compulsory liquidations, or voluntary liquidations, which may be on a solvent or insolvent basis. What we discussed today are the types of tools that would be available to a liquidator, particularly in a compulsory liquidation or a creditor's voluntary liquidation scenario. Those are instances where the company has ceased to exist, and the insolvency manager's role is to identify those assets and recover them for the benefit of creditors. With regards to the interaction of insolvency between the UK and other Commonwealth of Independent State countries, such as Kazakhstan, this is primarily overseen by the Untitled Model Law on Cross-Border Insolvency. As my recent reading confirms, neither Kazakhstan nor the AIFC court have yet adopted the Untitled Model Law, but that's not to say that recognition of foreign proceedings is ignored. In fact, having looked through the AIFC insolvency regulations, there is particular provision for the AIFC court to recognise foreign insolvency proceedings where the insolvency manager may be investigating assets to achieve a recovery. So I think there is in fact a clear indication of the AIFC court wanting to participate in international insolvency proceedings and indeed to cooperate with such processes, which is indeed encouraging. And I look forward to seeing how that develops as certain other opportunities exist. So that brings me to my conclusion. I hope that that has been an informative but short walkthrough about how the tools of insolvency can be used to trace and recover assets. I now open the floor to any questions which we may have received, and otherwise hand back over to David. Thank you very much, David.
Thank you, Jonathan. That was fabulous. Very relevant, very practical. I learned a few things today, and I appreciate that personally. Thank you. I'm going to ask my colleague, Almas, whether any questions have come in from the audience that he could then pose to Jonathan.
Yes, David, thank you. We have several questions. The first question is, which insolvency tools you think are more convenient to use when it comes to asset recovery support?
That's a good question. Thank you, Almas. And I think it all of them, but it depends on what stage of the insolvency you're at. Naturally, the front of the process is filled with investigation and information gathering. And I think those are critical. One thing I didn't mention in the presentation is that a lot of the work we do enhances on work that may have already been done. If there's a legal process that has already commenced a dispute, certain information may have already been gathered through disclosure orders, Norwich Pharmacal orders, which some people may be familiar with here in the UK, or indeed Section 1782 disclosure requests from the United States. Where such information has already been gathered, we can use that as assistance to what extra powers we have to gather information, which helps formulate the picture. So I think those tools that we have to force directors to come in for an interview, or to force lawyers or banks to provide their records for us is invaluable in quickly being able to ascertain whether there are any assets available for realization. I mean, as we spoke about some of the transactions which can be challenged, that is powerful to swell the assets as you get a bit further on into the process. Naturally, that is not even an opportunity if such transactions haven't been identified. So, from that perspective, I think the investigation's power is a huge benefit. Yeah.
Okay, one more question. The second question is, what kind of features and differences of insolvency procedures AIFC has in comparison with other jurisdictions?
Yes, thank you, Almas. I mean, I must confess, I haven't read through the AIFC insolvency regulations in its entirety, and if it's similar to the UK law, it is undoubtedly comprehensive over many pages. However, having looked through particular sections which relate to investigations within the context of insolvency, like we've discussed today. I think the audience would have seen that there are many similarities, entirely unsurprising because of the AFC court, as I understand, having formulated the insolvency process with the benefit of having considered how the UK insolvency legislation has been used, understanding the common law process, etc. So I would like to think you've taken the best parts and left some of the other parts which aren't so efficient in our insolvency law, which is now over 30 years old. With regards to other jurisdictions, I would say that every country is different, particularly any common law jurisdiction, such as the UK or the Commonwealth of UK countries, as compared with many Western European countries. Like I explained, at least up until Brexit later this year, the insolvency processes are recognised. We are not anticipating that to change as a result of Brexit because the UK is seeking to adopt other cross-border insolvency recognition of judgments in anticipation of that, which will keep it relevant throughout Europe. But in Europe, such as the countries that we discussed today, there are various differences. The process through which one needs to realize an asset in Italy is a very court-driven process where a judge will oversee that. And although the proceeds ultimately come back to us, that is entirely different to how the process would run in the UK. So it's not necessarily a challenge, but they are things to be aware of when embarking on such an asset recovery process.
Okay, one more question, the last one from one of our previous distinguished speakers from Ravil Kasilgov. He is asking, does Grant Thornton provide funding for litigation related to NPLs of local Kazakhstani financial institutions, which does not involve foreign jurisdictions?
Usually for us particularly to be involved, we need a connection to a common law jurisdiction, as that is our area of expertise. That now includes the AFC, and in particular, the opportunity for insolvency proceedings to be carried out there, where the assets may exist exclusively within Kazakhstan or any other CIS country. I will confess that that is not our area of expertise. And similarly, that makes it a difficult decision for us to invest our time on risk, or indeed through resolving non-performing loans. Stepping back from that, I would say, Almas, that if a connection outside of the country, Kazakhstan or the AIFC, can be identified, then that is very much of interest in terms of pursuing the assets, but also in terms of us providing funding solutions. Like I said in the presentation, we, like many other insolvency practitioners, are prepared to work on a risk or contingent basis at the outset, but we also have funding available to us to enhance that. And there are various ways in which that can be used. And I'd be really pleased to speak with any particular guests or attendees about some of the detail around that. Yeah.
Okay, thank you, Jonathan. At that point, David, we can proceed to concluding.
Yes. Thank you. First of all, Jonathan, on behalf of the AIFC Academy of Law, we thank you from the bottom of our hearts for this fabulous presentation. We know you volunteered your time for this, for the benefit of the students today. We know it took some preparation, and we are really grateful for that. You're a friend of the AIFC. We appreciate what you're doing to assist us in the development of this jurisdiction. Before we sign off today, just to our guests, we always like to do a little bit of reflective learning at the end of a session like that. So maybe just kind of sit back and ponder some of the things that Jonathan Thielmann covered today. Big picture, how do you use insolvency, the insolvency laws and procedures, to assist in international asset recovery? So you have a client, you've won a judgment, and now you need to enforce that judgment by seizing assets that may not be in your jurisdiction. So that can be complicated, but at the end of the day, it's not over until you've been able to recover those assets and claim victory so that justice is properly served according to the court's judgment. So some of the things that Mr. Thielmann covered today was, who do you need to assist in that process? How do you get started? This is a fairly specialized area. How do you even trace where the assets are? Where have they been moved? And how can insolvency proceedings actually assist you in a methodical, rational manner to serve your client's interests? And what if there are some complex offshore corporate structures that are involved that you need to sort through? And finally, what if you can't afford to fund the costs of pursuing the recovery of these monies or other assets in foreign jurisdictions? What can you do? So Jonathan Thielmann, who's the Director of Insolvency and Asset Recovery at Grant Thornton, addressed all of those topics in a very comprehensive and a very practical manner. So again, we thank you, Jonathan, for that. And to our participants, we hope this has been a valuable experience for you. We look forward to seeing you again. And Jonathan, thank you very much.
Thank you, David.
Have a great day, everybody. Goodbye.